Next is Graham Picklesimer. He is going to talk about impasse, the definition of impasse.
Yes. Hey, Susan. So yeah, for those of you who don't know who I am, my name is Graham Picklesimer. I work for the state headquarters office of United Faculty of Florida. I am actually based in Tampa, so local. And I assist a number of chapters of United Faculty of Florida around the state in labor relations issues, contract negotiations, contract enforcement, that grievance and arbitration business that you heard Sonia talking about earlier. And so here today to share some information about how the impasse process generally works in Florida. So little diagram here. So there's a few pieces to the impasse process, so we'll kind of go through each of them sequentially here. So don't worry about trying to digest the whole slide at once. Also, if you do have a question and when we get to the Q&A part and you'd like me to go to a particular slide and talk about it, just make a note. We have slide numbers in the bottom right corner here of which slide you'd like me to go to if that would be helpful in answering your question. Okay, so contract negotiations result in either agreement or impasse, and we've been having trouble getting to agreement, as you've heard today. If you like reading state statutes, you can read about the impasse process in section 447.403 Florida statutes. You can put that into your favorite search engine and read the full details of the process there. Although impasse is sort of what happens when you don't reach agreement, that doesn't mean that you stop negotiating. In fact, it's fairly common to continue negotiating after one or the other party declares impasse. You can make new proposals. You can TA or tentatively agree on proposals. You can withdraw tentative agreements before or after impasse is declared. So there's nothing magic about impasse that stops negotiations or prevents things from happening. Once you get to impasse, you've got sort of three roads you can take. Sometimes you take all three of them. Sometimes you take one of them, but there are sort of three options. The first option is to attempt a mediation, which is where you have some outside third party who kind of, gets both parties together and tries to use the power of reason to bring those parties closer to an agreement. There's a special magistrate process, which is where, again, a third party sort of listens to what each side has to say and the arguments in favor of their position for each of the bargaining proposals that are at impasse, and then sort of recommends a resolution for what they think would be fair and equitable in terms of resolving the issue in question. So on money, if, speaking abstractly, the union says we want 10% raise and the employer says, well, we think we can only afford a 2% raise, and the special magistrate will look at those and, kind of look at the facts and figure out what they think is a reasonable raise. In general terms, how that plays out. The third step, or third potential road, is to go to what's known as a legislative hearing before your board of trustees, and they have the final say. They can determine the outcome of issues that are at impasse. So we're going to look a little bit closer at each of these in turn. Mediation is something that both sides have to agree to do. It's not something that one side or the other can require to happen. There is an agency, the Federal Mediation and Conciliation Services. It's free if you go through that service, or you can, hire your own private mediator who may charge. The special magistrate process is, mediation is something that gets used occasionally, but not super often. The special magistrate process gets used a lot more often. And either party can require it. If either the union or the employer wants to use a special magistrate, then you use a special magistrate. There doesn't have to be agreement to do that. They do charge. That costs money, and the cost can, vary widely depending on how complex the case is. When a chapter of United Faculty of Florida goes to impasse, those costs are shouldered by the state UFF headquarters. That's not something that the local chapter would have to pay. As I mentioned, the special magistrate will recommend how he or she thinks an issue should be resolved that's at impasse. Either side can say, no, we don't like that. We don't like that recommendation. We reject it. If either side rejects any of those recommendations, then you go to a legislative hearing. So there's a section of that statute I referenced earlier that talks about what the magistrate does exactly. As I've said, they kind of give an opinion essentially on who they think has the best argument for each of the issues, or they could say neither of you has a good position and here's my alternative recommendation. That's possible too. They don't really get into legal questions like, oh, is it legal to propose this, or is it an unfair labor practice, or anything like that. They're not concerned with that. They're not a judge. They don't rule on those types of things. Their function is just to make a recommendation on what would be a fair and reasonable resolution to impasse. In certain situations, they can play a very critical role in actually determining the issues are at impasse. Sometimes the union and the employer have a different opinion about what's actually at impasse, so that could be interesting. If there's, no evidence that a particular issue has been an impasse, then the special magistrate will often find, well, okay, this isn't really an impasse, so I'm not going to make a recommendation on this. And I use the term issue, but it's not a technical term. You could be talking about a whole article, a section of an article, a single word. So issue could mean, lots of different things. There's another section of the statute, 447.405, that outlines what the special magistrate is supposed to consider, which, helps you think about whether or not you would have a good case if you went to a special magistrate. The most important things are comparison with other employers, and there's two categories. They're going to look at similar public employers that are nearby. In the case of a large state university like USF, they would look at state colleges in the area, maybe private universities not for public employers. They would look at other public universities in the area. They might look at Florida Polytechnic, they might look at New College, they might look at UCF as a nearby public employer. The other category is, similar public employers around the state that are kind of a similar size and nature. So they would probably look at the other big R1 institutions in Florida, UF, FSU, UCF, FIU. Those would be sort of similar to USF public employers around the state. They are to consider the interest and welfare of the public, which includes employees. It's not just, this abstract taxpayer, but also other, employees and other ideas of the public as well. There's a standard that's not really used very often, especially not in our work, which is, more academic intellectual labor, but, comparison of certain types of jobs versus other types of jobs. This is to capture things like, oh, well, this job is more dangerous, so it should be paid more than this other job that's less dangerous, that type of thing. But that's not too much of a factor in higher education. Finally, availability of funds. Perhaps obviously that's something that is considered when making recommendations about economic proposals in particular. The statute provides flexibility for them to kind of use other factors if they like, but those are the five explicitly spelled out in the statute. Okay, the third step or road you can take in the impasse process is going to that legislative hearing. So that happens if either the parties decide they don't want to use a special magistrate and they'd rather go to the Board of Trustees, then you go straight to the Board of Trustees. Or if you do go to a special magistrate and either party rejects any of those recommendations, then you go to the Board of Trustees. And the Board of Trustees has its own hearing, usually as part of one of their regular meetings, and they hear what both parties have to say, and they, nominally act in this neutral capacity, and then they decide what's going to happen on each of the impasse issues. There's some fine print to that. The board can't impose certain things. They can't impose language on what's known as a permissive subject of bargaining. What that means is kind of beyond the scope here, but that's kind of the limitation on their authority in that regard. There's one important thing that kind of happens when you go to the legislative hearing, which is that what's known as the insulated period takes effect. And when that happens, that means that the Board of Trustees can no longer communicate with anyone from the union or anyone from the administration on the issues at impasse. They're supposed to insulate themselves from the attempts of either party to persuade them on the impasse issues and, to preserve this veneer of neutrality. As I mentioned, there's one of two things triggers that insulated period. Either you bypass the special magistrate or one party rejects the special magistrate's recommendations. As soon as that happens, then you're in that insulated period. So the legislative body, the generic term for Board of Trustees in these circumstances, this is a direct quote from the statute. They take whatever action they deem to be in the public interest. And there's very little restraint on their ability to determine what is in the public interest. So they do have a pretty free hand to do what they want, subject to some limitations, as I just mentioned. Thinking back to what I mentioned a minute ago about the special magistrate determining that an issue is not at impasse, if the special magistrate says something's not at impasse, then the Board of Trustees cannot impose language on whatever that issue is. That doing so would be an unfair labor practice. Okay, and then there's something to be said about the role ratification plays in all this. You guys are, obviously you ratify contracts all the time whenever you negotiate them. However you get there, whether it's impasse or not, whether it's special magistrate, legislative hearing, mediation, whatever you do, at the end you have to ratify your contract. That's always the case. And as you may know, if you fail to ratify the contract, if the bargaining unit says, no, we don't like this, we reject this, then the parties go back to the table and try again. The exception when you go through the impasse process is that any issue that the Board of Trustees acted on is removed from the process. Whatever the Board of Trustees imposes, that goes ahead, whether or not you successfully or fail to ratify. Okay, so why would you do this? Why would you go through the impasse process? There's lots of potential hypothetical reasons, and I'm going to list a bunch, and they're all going to be pretty hypothetical. It just depends on your circumstances. If it looks like they're going to do something that's an unfair labor practice, you can file a charge, you can win, and then the employer looks stupid. And that is something that, you can use to demonstrate to the Board of Trustees or to the rest of the public that, the administration doesn't know what it's doing. And then maybe that's something that can be used for advantage. It can be, a focal point for organizing efforts. You can use the process. Sometimes you can get something better from the Board of Trustees than administration is actually offering at the table. It's rare, but it does happen. It can be something that the whole experience can be so miserable for them that they can say, look, Mr. or Mrs. President, you need to try harder to make sure that we don't have to do this again next year. So it can be an incentive for them to actually bargain in better faith in the future. But of course, there's risks as well. One of the biggest threats in a lot of situations is that the employer can change proposals. If you declare impasse, the employer can say, all right, well, if we're going to go to impasse anyway, we're going to bring all this other stuff that we really want, that we agreed to take away, but now it's all coming back. So that's something that can happen. If you go to a special magistrate hearing and you lose, you kind of look silly, right? Because then you've got this neutral third party that's telling you that they don't agree with your proposals. So that's a risk. It can delay ratification. It can delay, getting your raises pretty significantly. So that's not a decision to be made lightly. And just like it's possible to get something better from the Board of Trustees than you were being offered at the bargaining table, the other side of that coin is it's also possible to get something worse. That is a risk. You can also, I've seen unions sort of get into the habit of just declaring impasse when things happen that they don't like. And when you do that, it loses its effect. One of the main benefits of impasse is that it's a big deal when impasse happens, and you want the employer to learn that when impasse happens, that's a bad thing. But if you're just declaring impasse willy-nilly, then that kind of diminishes, that goes away. So I don't know how we're doing on time.
We want to leave time for questions and answers and Bob's comments.
Okay.
We can wrap it up there, and then if people have questions, they can ask during the Q&A session.
One thing I'd like to ask Graham is, what about discretion? If eventually, can they impose that on us? Like, for instance, we talked about starting salaries. Right now, the university has a total discretion to determine starting salaries. Now, if we put something on the table with a formula, can they just say, oh, no, we're not going to agree to anything. We're going to do whatever we want to in starting salaries. For an example, and that's why I look at impasse, can we take away discretion from them?
If you go to impasse and they and the Board of Trustees tries to impose language into the contract, either saying or with the effect that they can unilaterally decide how much people get paid when they get hired, that would be an unfair labor practice.
So that is the leverage we have, is to take away all discretion they have right now. All goes.